About marriage and succession matters to do with what just happened. I don't know whether it is the Marriage Act or the Succession Act, but this is why I brought our Kili here to have a discussion with us to tell us. My banner says unpacking the new Marriage Act. She's already told me there's nothing like that. Please join me in welcoming Advocate Grace NTEERE. Karibu.
Thank you so much, Levi. It's good to see you once again after a while.
After a while, yeah.
Yeah.
So you're saying it's not the new Marriage Act?
It's not. The Marriage Act is not new.
Huh.
The Marriage Act is for 2014. 2014 is how many years ago?
2014, 7 years ago.
7 years ago. You can't say it's new. What happened to the Marriage Act and the Succession Act? Actually, what was amended was the Law of Succession Act. Now, some of the amendments that were made on the Law of Succession Act are giving effect to the provisions of the Marriage Act. That's why we tend to mix the two issues in terms of amendment. What was amended is the Law of Succession Act, but the specific provisions that were amended touch directly on the
issues of
marriage.
Okay.
Yes.
How do we define marriage?
Marriage.
Legally now.
Legally speaking, the Marriage Act 2014 defines marriage as a union, a voluntary, with voluntary being the key word here, a voluntary union between a man and a woman. Yes.
Voluntary union.
Between a man and a woman.
So where does Can We Stay fall in there?
Can We Stay is, I think, they just...
It's a union, it's voluntary.
It's a presumed union. A voluntary union between a man and a woman that is registered. That is a valid marriage. So it should be voluntary between a male and a female.
Yeah. And you don't have to register.
You have to register.
You don't have to register simply with like the Attorney General. They do recognize customary.
Yes, that's what I was coming to.
Okay.
There are various types of marriages that are recognized by the Marriage Act. So further to the definition the Marriage Act 2014 gives a marriage, that it's a voluntary union between a man and a woman. It goes ahead to give some of the, I would call them requirements for this union to be a valid union. Because you see, the Act says you being a male and a female alone doesn't qualify this to be a marriage. It has to be a voluntary union. Number two, it has to be between persons who have the capacity to contract a marriage. By the capacity, I mean over 18 years old.
Sane.
Yeah, sane, of sound mind. Number two, you're not in another union, so that by law you're not prohibited from contracting another one. So you must make sure at the time of contracting this marriage, you're not in any other union. Number three, it must not be a union between, there is a class that is identified in the Marriage Act of people who cannot get into a union that can be called a marriage. So it gives a definition of relatives in terms of, cousins. Yeah. So it highlights some of those people who cannot, you cannot contract a marriage. So for you to say that you're legally married and in a legal union, look at the requirements of the Marriage Act. If you rule out all the exceptions, and then you can proceed and
and yet polygamy comes into play.
Yeah. The other thing that the Marriage Act gives, the Marriage Act 2014, gives some types of marriages that are recognized by the Kenyan law. Number one, we have Christian marriage.
Yeah, mbele ya pastor.
Mbele ya pastor, of course, mkimaliza you go and register. They recognize Islamic marriage.
Yeah.
So, but that one now has to be, guided by the Islamic
Sharia law.
The Sharia laws. It recognizes Hindu marriages. It also recognizes customary marriages, where I think now, polygamous marriages or polygamous unions fall under customary law.
Yeah, so that's...
And if you are to contract a customary marriage, that is, we call it a potentially polygamous
How do you prove though that
Prove that you're married.
That you had a customary
A
marriage?
customary marriage.
Yeah.
The
others have certificates.
The others have certificates.
Yeah.
What usually used to happen in the days ago, you had to prove that, number one, you are being maintained by this person. Number two, you have to prove that there was a customary ceremony. Like in Kikuyu, they call it Rorashio. In Kale, they will call it Koito.
Yes.
So you find that these customary...
Oh, it's good, you know.
Yeah, I know, of course.
Impressive,
so,
yeah.
Yeah, so at the end of the day, you find that these traditional ceremonies were what used to determine, or they were very key in distinguishing a customary marriage. So if you had a koito and you don't have a marriage certificate, you will say, in case of anything, I was married to this guy. We went to their home, they paid the dowry, they gave or whatnot. So for you to prove the...
And there are certain things was theirs right down.
Yeah, they write down according to, of course, now the culture of each person. So at the end of the day, proving a customary marriage was more of showing what has been brought to your home. This person has visited our home. The wazayas have sat down and talked. Because you see, you don't have a certificate. But you remember the last time I was here, Levi, I told you that regardless of whatever union that you've contracted, by 1st of August 2017, it was a requirement by law, whether you've contracted a customary union or whatever kind of union, it needs to be registered for you to be able now to claim that you're married.
Yeah.
You see? So to that end, the recognition of a marriage by the Marriage Act, it recognizes those forms of marriages. Yes.
Okay. So with that being the stage for what we are supposed to discuss right now, maybe I'll just ask,
Yes.
In terms of what changed, what was the major thing that changed from the Act of 2014 that that's standing out so much? Or that was added? Was it added, removed?
What happened, the Law of Succession Act, there was a bit of confusion between the Law of Succession and the provisions of the Law of Succession and the provisions of the Marriage Act, in the sense that the definition that the Marriage Act gave of, let's say, a wife or a spouse could conflict with the definition that the Law of Succession gave of a wife. So when Honorable Peter Kaluma presented this bill, it was for the amendment now, which has already been amended, for the amendment of the Law of Succession Act. We were trying to cure this inconsistency within the two acts so that we harmonize them. At the end of the day, basically what it was touching on is matters of inheritance. So that you don't go to court and seek, for the court to clarify what a wife means, because this law says this and this other law says this other thing. So Peter Kaluma was generally trying to cure the inconsistencies between the Marriage Act and the Law of Succession Act. And in doing so, there were, I think, about 4 sections that were amended. Section 29, 32, 35, and 39 of the Law of Succession Act. These sections directly touch on the provisions of the Marriage Act. That's why now we are saying it's like the Marriage Act has been amended. Technically, it has not been amended. It is the Law of Succession Act that has been amended to give effect to the 2014 Marriage Act. And one of the amendments of Section 29, the definition of a wife.
Okay.
You see.
So who is a wife?
When you ask somebody who is a wife, somebody will just say, it's the woman that I married. But for purposes of succession, a wife is somebody, or I would say a wife is somebody that you could give, you have a marriage certificate for purposes of succession. This is a person who can prove that you are married, legally so. So that when it comes to succession, when the Law of Succession is listing the dependents of the estates of a deceased, the wife ranks first.
Okay.
So there was the issue of a wife and a spouse. Now, what the amendment has done, it has removed the provision that a wives or former wives. Now that becomes a very interesting
Very
discussion.
interesting. Yeah, we are already.
Because now you,
We are quickly at former wives.
Levy is about to ask me about the secret wives, who they call
Yeah,
pangos and
No, you
the
said
side
wives.
pieces.
Wives can prove their wives. That's why I asked you earlier on about this whole customary marriage. And how do you prove? Yeah?
Yeah.
Because, you know, if you're a wife
Yes.
who has a certificate, it's straightforward.
Yeah.
You got married in a church, you bring your certificate.
Yes.
No, there's no certificate of divorce, you are the wife. You know, if you are a wife who was married because some goods were taken to your place, you know, then yet there may have been another wife, the way you are married also. How do you?
Now, what this amendment has done,
How does the burden of proof?
the burden of proof has been reduced to proving. And proving, you remember I've mentioned earlier on that there was a requirement that every union must be registered, whether it was customary, potentially polygamous or whatever, it had to be registered. That was the requirement as at 1st August 2017. So right now as we speak, the person who is entitled to inherit as a wife is the person who you are legally married to. By legally married to is the person who will produce the marriage certificate. Now the question now comes, now where do the former wives, children,
secret wives, where do they go? Bangos.
Yes, where do they go? I would say, as at now, the act is more clear. So that at the end of the day, we don't get people, when the deceased is gone, you don't get people running to get court orders for burying burials because I was married, what, you know.
Yeah.
The act has actually put it so clear that a wife, for purposes of inheritance, is somebody who is legally married to you. So that when you're going to, if you're going to object the probably burial of somebody on the basis that you are their wife, what do you have to show? So the next question would be, now what happens? Yes, I do not have a certificate, but I have children. Where do these children go? So the act, what is technically saying, a wife, for purposes of succession, is that person who prove. And it goes ahead to say, you cannot disinherit a child now when it comes to dependence, just because the child was born.
Just because the mother cannot prove.
Yes, the mother cannot prove. A child is a child for all intent and for all purposes of succession. Whether at the time of death of the deceased, he was maintaining this child, whether at the time of death of the deceased, he wasn't maintaining this child, they are entitled to inherit from the estate of the deceased. Okay. That is what now the Act has actually brought out so clearly. Okay.
Yeah. So the message being sent home, if I get you correctly, is that if you are a wife in a union where it's not registered in any form or manner, then you need to speedily correct that situation.
Exactly. Because what the Act has done, it has actually excluded former spouses, former wives, all those other things.
Hakuna ile even until relatives even know me.
No. Yes, the relatives can know you.
They've seen me around.
They have seen you around. But you might have been like a visitor, like the way I'm a visitor here today. I'm a good friend of Levi. I mean, I came to say hi to his family. There's no harm in that. Today I can get a few of my friends. We go to my village, go say hi to my mom. That does not prove a marriage. So for anyone who is listening today, just know that the Act now is more clear in terms of the locals that were there, that people were rushing to court to say, no, I am a wife, I am a former wife, we have children. Yes, the children are well taken care of. And it is so clear in black and white out there that a child is a child for purposes of succession. regardless of whether the father disappeared 20 years ago. If they come and produce a marriage certificate or probably a DNA that links them to the deceased, they're entitled to get something.
And this is now the law.
This is now the law.
This is now the
Which
law.
has been brought. There was I think the issues we had at the High Court in terms of succession matters. There was a bit of disconnect between the two acts, so that if you want to go and file for a succession, probably you're the former wife. You know, the act previously provided for a former wife, wives. And then the act is saying a wife is somebody who is legally married. You know, there was that disconnect, which has now been brought to the limelight so clearly, such that now we expect, probably going forward, anyone who will be approaching court for these succession matters, you know, you have a clear leeway of who can approach court rightfully. Yeah.
Well, we'll take a break on that note. When we come back, we want to go through what else was. You're saying not changed. Is the word amended? Is it changed?
It's amended. So amendment is like probably enhancing what is already there or removing something that is not, so that there is clarity in the act.
But they say the law always comes to cure something.
Yes.
Yeah, you will tell us as we go. What are we curing here?
Okay.
You told us about these wives and what we were curing. We were curing the drama of you know.
Yes.
Post-death.
Post-death, yeah.
You know, because
that's what basically the Marriage Act and the Law of Succession Act deals with. So if you were to look at it at the end goal, at the end game of these two acts, it's to bring some order once you're gone. Yeah. So that you don't leave your...
So kama hukujipanga, tunakupanga vizuri.
Tunajaribu kukupanga. But pia kama unaweza jipanga, the last time I was here we talked about wills. It's good to just do a will. Kama utaki kupangwa na hizi acts, jipange before you leave.
It's interesting. You know, it's coming at a time when people are so used to saying, hatupangwingu.
Hiyo mnasema mpangwingu, the law will wapanga all of
you. We are discussing matters to do with succession, matters to do with marriage, talking about the Marriage Act and matters that came in that have to do especially with succession. Issues to do with children, actually. Some of the things that were interesting about that, the amendment that was made to the Act was, I think there was a portion that men really talked about raising a child, you know, and the input being 50-50. Ni kweli ama
that's not on the Law of Succession Act. There is a proposal. Actually, it's a proposal. There is a proposal on the amendment of the Children's Act. It's still a proposal. It has not been.
It's not law.
It's not law yet, but there is that proposal. We could talk about that, the children and the law, in another session.
In another session. But you know, guys have been saying, you know, the things we are speaking about outside there. What wanasema unajua hiyo sasa. Mambo ya mabibi tumedeal nayo, kurukaruka. Kuna mambo ya sasa ya pesa. So now we know, now we hear it's not even law.
There is a proposal. Actually, I think it's been tabled to Parliament. I think it's not been it's not gone through yet. But there is a proposal for the amendment of the Children's Act 2012.
Okay.
Yeah, that one we'll discuss once it's.
Okay, so for now, tuvumilie.
For now, tuvumilie. Of course, people. These rumors tend to spread like fire. I mean, and it's not law yet.
Those are the things that excite people the most. And then, of course, the issues.
They should be excited more about this Marriage Act, because you just going to church and doing a wedding, you know, does not end there. Get the certificate, of course. I think they say after 14 days of doing a church wedding, you get the certificate, get your union registered and whatnot. So that when that time comes for inheritance, which is a very emotive issue, actually, you know, you've put your house in order. And one more interesting thing that this amendment of the Law of Succession Act brought out so clear is by removing the word wife or wives or former wives and introducing the word, actually it was replaced by the word spouse. So that now a definition of a spouse is a male or female. You know, Kitambo, what used to happen, Levi, and you bear me witness, is that the burden of proof of a spouse, a male spouse, when it comes to issues of succession, the male spouse was, the burden of proof was a bit higher for the male, whereas you see the female, they were not tasked to prove that you're married to this guy so that you could inherit from him. So now what has been brought out so clearly, and it's very interesting, is that the introduction of the word spouse to mean a male or female outrightly brings the fact that a male, you Levi, and your wife, you can actually inherit from her without having to prove that you're married. Just producing a marriage certificate, you don't go, beyond the marriage certificate. Because now that the amendment has cured the inconsistency in terms of, okay, it's only a wife that can, inherit from their husband.
Amen to that. At least men,
so now
men will have a chance to access.
Now you can inherit from your wives.
Including
it is so clear because
all
the introduction of the word spouse, replacing wives. See, the one for the previous provision was just talking of wives or former wives.
Yes.
You see, there was no husband somewhere, so there was
yes.
that ambiguity. And or more so to speak, the act was bent towards. Spouse opened it up in the sense that a spouse means a male or female.
I think it's a very, very nice thing.
It's very interesting because
it means
now
all the money mama anaficha kwa chama utapata tu.
Pesa ya chama, don't talk about that. Pesa ya chama. That is not matrimonial property.
You get eventually.
Hapa I will tetea kina mama, you pesa ya chama, just leave it out of your matrimonial
of that discussion.
Out of that discussion, because you don't want women coming.
But it's good because at least it gives at least a 50-50 chance, because we did see.
It's not actually a 50-50. It's like so long as you're married, I mean the wives, former wives or whoever has been removed. A spouse has been introduced. And by a spouse, it is male or female. So at the end of the day, the only thing you need to do if you want to inherit, if your wife, goes before you, you just produce a marriage certificate. So you'll not have issues to go and, start saying, no, you see, I am the husband, and this is the arrangement we had, I was being maintained. You see, the previous, the way the act was worded was limiting to the extent that a male had to go an extra mile to prove that, we were married, because of the mere fact that the words used were a wives, former wives, or a former wife. So there was no mention of a husband somewhere. So that's why we had an issue. But right now, that has been cured by introduction of the word spouse or spouses.
Yeah.
So if now they can, produce just a marriage certificate, you don't need to go to an extra mile of, proving that you're married for you to be able to inherit from your spouse. So a spouse is a spouse for purposes of succession. That's how I can, generally put it.
Yeah, that's good.
Yeah.
So what else is there? Take us through it.
What else has been changed? Of course, apart from the definition, of course, there's the issue of community land has been removed from the inheritance proceedings, such that community land will not be subject to, inheritance proceedings. So that no one will lay a claim and say, you'd see my husband or my wife was, I don't know where, doing what with the community land, so I'm entitled to inherit from the community land. So I think this one preserves the cultural practices and cultural property, I would say, so that no one is going to lay claim over a land that is defined to be community land.
Yeah, so
it remains community land. Yeah.
I hear you.
Yeah.
Now on children, we just have about 15 or so minutes. Talking about children that what was the time? It wasn't marginalized. It was I don't know the terminologies for the children that are not. They are the children out of wedlock. Yeah. And then they are the vulnerable children.
Yeah. Now, I would take it as a scenario to explain this. Yeah. What the Act has done, it has put the record straight, such that, Levi, if you have a child with me, and you have the children with your wife, and you have another child somewhere else, all these children, in case you depart, all these children, regardless of whether we were in talking terms, me and you, at the time of your demise, regardless of whether you used to pay school fees for my child, or regardless of whether you used to, pay maintenance or, provide the basic necessities for the child at the time of your demise, this child will be entitled to inherit from you. So whether you liked that child or whether you didn't like her, whether you liked the mother or didn't like the mother, whether you separated in very good terms or in the worst terms ever, that child, for purposes of succession, that child is entitled to inherit. What some of the arguments that used to be there before was that at the time of your demise, you are not maintaining this child, and the burden of proof would be put probably on the mother to prove to court that at the time of your demise, you are paying school fees for the child or maintaining the child in one way or the other. So that has been now removed to say that...
and it was used to disinherit a lot of people.
Yes, actually so many children were disinherited just because of the mere fact that, of course, you separated with the father, and the father is nowhere in the picture. So he doesn't pay school fees, he doesn't do anything, and now he's dead, you cannot claim anything. So what the Act is saying right now, a child, whether born in wedlock or out of wedlock, if there's something like in wedlock, is entitled to inherit.
Don't you think that will open up the floodgates for more litigation?
One thing I'll tell you, Levi, the law does not operate retrospectively. Now, whatever interpretation anyone wants to do with that, of course, now we'll see more of applications now in court to include children who are disinherited. Of course, we'll see so many grants being revoked, probably, but as I've said, the law does not operate retrospectively. So going forward, what I'm looking at is, like, going forward, we'll have a more clear way of dealing with issues at the succession courts in terms of the courts knew that regardless of what happens, regardless of the sideshows and the dramas that surround, people parting ways, where a child is involved, that there is no discussion about that. That child, you cannot bring anything against it. To disinherit a child, no. Whether the child was being maintained, because some of the issues that led to disinheritance of some of the children were that somebody will come and say that, no, at the time this person died, he was not maintaining you, he was not maintaining your child, he was not paying the school fees for your child, I don't know why you're coming to court. And you see, since the act was not so clear, the court would be bent now to, look at and weigh the options that they have. Of course, it's at the discretion of the court that indeed this person has not been in your life for the last 10, 20 years. What are they claiming?
Is this inheritance only based on if you are a child, as in if you're under 18, or if you're over?
A child. I am my father's child, if I would say that.
Yeah,
I am my father's child.
Because you've seen people, come and say, people of my age say, that was my father, but I did not know him. And
a child doesn't know any age. Even at 50, at 50, 60,
so the definition of the child here is the child of the person, not so much the age.
We are not talking about the age. The age only comes in at the issues of marriage, so that you cannot contract a marriage unless you're 18 years. That's all. Or when we talk about the Children's Act, or the issues of rape, a minor, whatever.
Yeah.
But for purposes of succession, a child, whether you're 8 months old, whether you're 20 years old, whether you're 40 years old, you are entitled to inherit from the estate of your parents.
Yeah.
So that even me right now, if I want to inherit, no one can, claim that I know you're grown up, you're an advocate, you have your own things, you cannot inherit from your father. I will rush to court very fast.
Yeah, but you better because if you don't, then you bear the cost of the litigation.
For a child, most of the times in succession, in matters to do with family, like I would say family division matters. The issues of costs, of course, being a family issue, and you still want to, have some dignity within the family. You don't the court doesn't award costs. Everyone bears their own costs. Because if I take a suit against you, Levi,
Yeah.
we're in the same
But
family,
what's
and then you're forced to pay me cost.
Okay.
I mean, that is, you know, you're like creating a war now.
But what if I bring a frivolous lawsuit? Like if I go and claim I am, you know, one of Moi's sons.
And you cannot prove it.
Yeah,
You
now
know,
that-
the
now that
only
they are
thing that
there-
can happen,
now that they are dissecting property there,
the same
you
will
know.
just be dismissed.
You know.
Yeah, the same will just be dismissed, because at the end of the day, the institution of like not marriage per se, but a family, you don't want to bring issues that would you know, open up the family to fights and whatnot. The courts try as much as possible to maintain, you know, the dignity within a family, so that if an issue like costs is likely to bring animosity between siblings or between relatives, and then they would avoid that. So that at the end of the day, when the court is making a determination on an issue that had been presented before it, it takes into consideration that at the back of their minds, they know this is a family. And what we are trying to do, we are trying to cure this problem that they've brought us without creating more problems. So for succession or matters at the family division, it's highly unlikely that you hear costs have been awarded. Everyone bears their own costs. Of course, there are exemptions which are there, but that should be the general rule. Yeah.
So the matter about vulnerable children, what are they alluding to?
So the Constitution of Kenya 2010 clearly identifies children as a vulnerable group. And by vulnerable, I mean in all sense, a child is vulnerable because this child doesn't have anything of their own. They are fully dependent on the parent. So we could say the degree of vulnerability. Kimeru. It's my vulnerability. My people have represented you so well. So I have done very well. So the degree varies because an orphan, you cannot say an orphan is at the same degree of, you know, being vulnerable as somebody who has both parents. Yeah. So what the law tries to do in terms of differentiating these, you look at this is an orphan, you have two parents, this is a person who's born by a teen mother, you know. So there are those issues that, you know, bring together these children, and you look at it from an angle of these are low-income family, these are high-income, you know, family where this child is coming from. So on succession matters, a court that what do we call it? The proceedings might drag for a while. You have this group, maybe you have an orphan, you have somebody who comes from a low-income family, and you know, with the amount of time that it might take, you might see that you're subjecting this group of people that we call vulnerable to, you know, unnecessary, you know, you're called for mentions every month, you know, probably you don't have the financial muscle to maybe ferry yourself to the court. So what the court says, it will focus more on avoiding unnecessary expenditure in terms of bringing the children probably to court, and where such a group is involved in succession matters, the court tries to expedite the proceedings, so that at the end of the day, it's not like a punishment when children are involved. So somebody might go to court and say, probably I filed my matter in 2015 and it's not been attended to, and somebody filed in 2019, they're almost, you know, concluding. But what they don't know is the courts look at actually the pleadings and the kind of people you're dealing with, so that you do not have to subject an orphan to those lengthy proceedings, and probably they don't have anywhere to go, or they don't have anyone to go to. You see, you cannot compare an orphan with somebody who the parents are there, you know, you have everything.
So they stagger the process of justice.
Yeah. So what they don't stagger the process of justice. What they do, they try to make sure that this orphan or this person who comes from probably a low-income area is accorded, you know, justice at the shortest time possible without necessarily make them feel like they are being punished for being an orphan. You know, somebody might go to court for a while and they're like, are you doing this to me because my parents died? Yeah, they're not there. You know, so what the courts do actually at the family division, they try to look at all dimensions when it comes to matters inheritance, succession, and even children. I think we'll have a discussion about children and the law and the Children Act, probably if it will be amended or not. We'll have a conversation about that so that you realize when dealing with children, there are different dynamics that the court employs. That is completely different from you know, when dealing with an adult like myself or yourself.
Yes, from listening to you, it seems like the courts have a lot of humanity in them.
You see, we are. I will tell you this, Levi. In our system, in our legal system, I mean, in our justice system, we are pro-child. So that at the end of the day, everything that you know, we do, the interest of the child is always paramount. You know, you're not trying to bring up a generation that is rebellious and saying, no, you know, there's nothing that works in this country. Of course, there are a few of them who will say nothing is working, but at the end of the day, all our systems are geared towards ensuring that a child of whatever nature or wherever they come from, their interests are well taken care of in the law. So that, you know, again, to avoid that rebellious nature. So all issues, that's why you have juvenile courts. Again, it's a discussion for another day, juvenile courts, so that a child is not taken to the same court that myself I would be taken. You know, they try to make it, I would say, a friendly environment for the child, in as much as there are issues that cannot be avoided. They try to make it more friendly for the child to be able to, you know, live through.
I hear you.
Yes, yes.
It's unfortunate we're out of time, but there was still so much to say. What would you tell someone watching from home? It's really the take-home here. How do you familiarize yourself with what's going on legally and the new changes as a layman?
Now, what I would say, and what I would insist actually, is if you're in any union, any form of union that is not registered, please regularize that position. So that at the end of the day, the law is not there to come and put your house in order. It's you is actually putting your house in order. And also, if you have those other issues there, just know that if you have your children, by issues I mean children. In law, they are called issues. Just know, even if you don't like their mother, or you don't like where they come. yes, you don't like where they come from. At the end of the day, that's your blood. They're entitled to inherit from you, so you cannot disinherit them. So whether you do a will in terms of putting your house in order and you disinherit them, they will still go and successively claim for a share of your estate. So put your house in order and avoid some of these issues that are so rampant nowadays.
I hear you.
The courts are actually flooded. You might get a date of 2023, and you wanted to bring something, you know, to a conclusion so fast. So to avoid all that back and forth from the courts, it's good that regularize your position in terms of marriage and whatnot, and put into consideration when you're doing a will, put into consideration all your dependents. And I mean, that it will be easy for everyone. Even when you're gone, you also rest in peace.
It's a good time to discuss these things because we're almost at the end of the year. So basically, Wakili is saying, stop singing Haupangwingwi. Jipangi. Because the courts sitakupanga. There's no...
there's no two ways about it.
No two ways.
Even if you sing Haupangwingwi for the rest of your life, I mean, if you've not put everything in order and in the right way, the courts will have to kupanga you.
They'll have to panga you.
And
you might not like it because you're not there to even, you know...
you'll just be turning in your grave, but you can't do nothing about it.
You can't do much.
I
hear you. Thank you so much, Grace.
Thank you so much, Levi.
Advocate Grace NTEERE, teaching us about matters to do with the law. Always a pleasure. We look forward to doing this more next year also.
Next year, please call me. We do Children Act.
And also Elections Act.
Oh, that's a matter that is so close to my heart, though I don't look like I say it so often.
Seriously? We've got to talk about elections.
Yes, next year then we
so you can vote within the confines of the law.
True.
All right.
Yeah.
Good morning, good day, God bless you. Stay tuned for Leah coming up with the lawsuit. See you tomorrow, God willing.